Welcome everyone here as well, and welcome our online audience as well. We're here to talk about community associations in the digital age, and we're going to talk about three main topics today. One being data retention, another having to deal with social media, particularly copyright law, defamation, and then we'll talk about some general concerns and how to keep yourselves out of trouble. We'll be co-presenting today with my colleague, Kelly Callahan. Kelly's a great attorney. He's been with the firm. How long, Kelly?
Just over 5 years.
5 years. She knows her stuff. One of our top writers, if not the best. So you're getting a real treat today. So without further ado, I'm going to turn things over to Kelly. Thank you.
Thank you. All right, so we're just going to jump right in to data retention and technology. Maybe. All right, this clicker's not working. So we're not going to jump in yet. Let's try this one. This one works. All right, for the quiz question, though. Sorry about that, guys. I'll use two clickers. Okay, data retention and technology. What we're going to speak a lot about today is the way that advances in technology have impacted community associations in terms of record keeping and practices as far as maintaining websites, Facebook accounts, Twitter, social contacts and communications, internet in general. But what I'm going to primarily focus on with you is data retention and how your association may or may not be complying with the applicable statutes. So, as you know, in Arizona, we have the Nonprofit Corporations Act, the Planned Community Act, and the Condominium Act, which apply based on what type of community you're dealing with. And one very important note that we'll start out with today is the record requirements that are set forth in these statutes impact not only just your paper keeping in your old-fashioned file cabinet that may be in the corner of your office, it also impacts your electronic records. So when we are thinking about record keeping, we need to get our minds in the familiarity with we're talking about more than just paper. So we're talking about emails, we're talking about voicemails, digital recordings, audio recordings of meetings. Everything is all encompassed in that umbrella term of a record under Arizona law. We're going to try a quiz question. We'll see if it works. Yeah, it's not. Can you hit start, Javier? Thank you. Okay. Which of the following best describes your community's data retention policy? We keep everything forever. This isn't going. Sorry, guys. Having technological difficulties, which is ironic given the seminar. Neither one of these is working.
At least it's consistent.
We're just stuck on keeping everything forever.
It's moving now.
Okay. Oh, sorry. Okay, sorry about that. Which of the following best describes your community's data retention policy? Do you keep everything forever, not keep anything, keep everything for a certain number of years? Thank you. It depends, or we don't have one. I'm going to start the, sorry. Vote again. Thanks. Pick which one best applies to your community. If you're a manager of several communities, do your general policy. We'll wait a couple more minutes here. I'll wait until we get to 20 seconds. All right. So the most common answer we've got today is we keep it for a certain number of years, followed by it depends, which is pretty standard that we'll see across the industry. I'm going to hide that and move forward. Okay. So what we'll talk about today is what types of records we're required to keep for how long and why having a policy will be helpful for those records that don't really fall into any specific category. The Nonprofit Corporation Act requires associations, whether condos or planned communities, to keep certain types of records as their permanent records of the association. Whether you keep them electronically or in paper format, is not specified in the law, and that's one of the many reasons why it's a good idea to have a document retention policy that specifies how you're going to store these records. So typically what is considered one of the permanent records of the association is going to be all of your governing documents. So that's CC&Rs, bylaws, articles of incorporation, design guidelines, architectural rules, etc. We'll also have board resolutions, meeting minutes, and that covers both board meetings and member meetings. Actions taken without a meeting, sorry, that's covered by the box there, but actions taken without a meeting, so your unanimous consent actions by the board are also going to be included in permanent records. Actions taken by a committee on behalf of the association, so that will be, for example, if an architectural committee comes up with a policy or a decision, that committee action on behalf of the board is part of the association's permanent records. Architectural decisions about a lot. Accounting records, and I'll put a sort of caveat to this one. The IRS recommends that you keep your typical financial accounting records for 7 years. So it's not necessarily that you need to keep from 1965 to 2013 accounting records, but at least the last 7 years is typical best practice from the IRS standpoint. And you need to keep a record of members that indicates the type of vote or amount each lot is entitled to. Typically, it's going to be one vote unless you're in a condo and have sort of a different arrangement, but a record of who the members are and what their voting entitlement is. That is all found in the Nonprofit Corporation Act at 1033-601. All right, we have another quiz question. We'll hope it works better this time. Arizona law requires that records related to removal of a board member must be kept for how long? 1 year, 2 years, I'm not sure we have a third choice, 3 years, indefinitely, or there is no requirement. Okay, polling is open. Records related to removal of a board member, how long do they have to be kept? We'll wait a couple more seconds. Close it out at 15. And, all right, kind of split. We've got 10 for indefinitely, 8 for 3 years, 2 for 2 years, 2 for 1 year, 3 for no requirements. So we're kind of all over the place with this one. I will tell you that the statute requires you to keep records related to removal of a board member for 1 year. It's surprising because that's typically something that's rather disputed, a cause for a lot of drama in associations, but the statute only specifically requires that those documents be kept for a year. So what about other types of data that aren't included in the general permanent records and that aren't board removal related? For example, written communications to members, a newsletter, notice of a meeting. Those types of documents need to be kept for 3 years. What about miscellaneous emails, lot file information, stuff that just doesn't fit into any other category? Those are not specified in the statute. And for that reason, we highly recommend that associations consider adopting document retention policies that I've referenced a couple times already today. What a document retention policy can do is it allows you to come up with a standardized way of defining what your association considers to be a record, what information is going to be retained by the association, how it's going to be retained, where it's going to be retained, and for how long. So that way, if you do have, say, an overwhelming amount of records, maybe your association's been around since the 70s, you've just got papers and discs and CDs, what do you have to keep, how long do you have to keep it? Some things aren't going to fit into a broad category that the statute defines. If you have a policy and you always abide by that policy, then in the event that something does go wrong in the future or an owner asks for something that's been destroyed, at least there's a reason and a method of practice that you've established and regularly abided by that shows that it's not just a mistake or something more sinister, that you didn't destroy a document, but you have a policy to point back to for the reasoning. All right, what about in the event of litigation? Obviously, we recommend that you do not destroy paper or electronic records related to an owner that's in litigation with the association or that's threatening litigation. Your duty to preserve records arises when you reasonably anticipate litigation. Now, that's a difficult point in time to nail down because everyone knows there's going to be owners that threaten to sue the association every time they're upset on a weekly basis. There's also going to be owners that never make a peep and then file a lawsuit. So it's really difficult to nail down what point is supposed to be my reasonable anticipation of litigation. Not a great legal saying, but it's a little bit of a gut reaction combined with your experience, I think, and obviously any threats, verbally or in writing, of litigation. If they have an attorney involved, it's always a possibility that there'll be litigation. Just got to kind of use your experience and what you've seen happen in the industry to kind of clue you into what could be reasonable anticipation of a lawsuit. You should preserve not just your paper records, but again, everything, including electronic records that you have available. We had someone at the seminar this morning that said her association makes an audio recording of the meeting minutes and then uses that audio recording to transcribe written meeting minutes, and then deletes or discards the audio recording after the paper minutes are created. And she said she had a really bad meeting last week, and it was very dramatic, and she's 90% sure that litigation is going to come from this bad meeting. And she said, if our policy says destroy the audio recording because I already made the paper version and we have minutes, should I still keep the audio recording because I'm anticipating there could be litigation? And what we discussed is, because of the context, because there's a large possibility that a lawsuit or a dispute of some sort will result, best practice would be keep everything. Do a suspension of your discard records procedure in relation to that issue or that owner, just to be on the safe side. Now, generally speaking, I think if you just have a calm meeting, nothing out of the ordinary, and now you've got an audio recording and a paper copy of minutes, you probably don't need to keep both, and that's something you could specify in your policy, that generally speaking, we're going to record it, we're going to write down the minutes afterwards based on that recording, then we're going to destroy the recording. At least have it written down, because that's always helpful to point back to when someone tries to raise suspicion about why you may have deleted a record. But in the case of, dramatic board meeting, dramatic interaction in the manager's office, bad phone call that happens to be recorded, it's always on the safe side to keep that stuff in case a lawsuit does result. All right, and finally, I just want to make a quick point about using email to communicate amongst board members. We had a brief discussion about it in our morning meeting, essentially related to the idea that some people believe that exchanging emails amongst board members constitutes a meeting. And that's because Arizona open meetings laws, which relate to public bodies and governmental entities, require meetings to be open, and they define meeting as meeting by electronic communication as well as in-person contact or via conference call. So if you're a governmental or public entity, transacting business over email can basically violate the open meetings laws. That's not the case with homeowners associations, because homeowners associations are not public bodies, they're not governmental entities. However, it's still a good idea to limit email conversations as much as possible. I know it's difficult, but the problem with using email all the time to transact business outside of meetings are that you've got this risk of commingling the board members' personal emails with their association emails. That's always difficult when you're in a lawsuit. The other side serves you with discovery requests, says, Joe Smith uses his personal email to do all of his board business. I need access to Joe's email account. Then Joe's personal email account's open to the attorneys, the other side, and it's unnecessary if we can just work on creating a culture where we set up separate email addresses for board members. It's just a good idea, it's free, it's easy. Another risk in overusing email is that perception that the board's transacted business behind closed doors is showing up to go through the motions but isn't really talking about anything. We're just doing some votes, but we've done all of our debate behind the scenes. That doesn't foster the communication that the open meetings are supposed to be intended to foster, and it raises suspicion when there's really no reason for it. Likewise, there's this appearance that you've predetermined the result before the board meeting, which kind of defeats the whole purpose of the few people that ever do really show up to the board meetings in the first place. So to the extent we can limit our business in email transactions, it's just generally a good practice. The other risk, of course, is it's been in front of the legislature several times where the various legislators seek to include associations within the restrictions that encumber public bodies. So it's always possible that it could be one bad association situation with an owner gets mad about the board conducting business in email, goes to their legislature decides to take it up as their passion project for that session, and we end up with a law that does include the association in the public bodies type of regulation. So it's just something to keep in mind as technology becomes more and more a part of our association practices. And now I'm going to turn it over to Javier.
Passion
Which one you
project. I
want?
love the terminology. I'm going to go with the
Okay.
blue one. Thank you. All right, well, thanks for sticking with us, folks. Just a survey question. Something we talk about internally in the office quite a bit. For those of you who are community managers, who work with more than one community, I'd like you to think about your most representative community when you answer this question. If you're a board member, just go ahead and tell us what your association does. How does your association use social media? Does it utilize a website, Facebook, Twitter, like some type of email push program, notification system, or one or more of the above? This way we can kind of just learn a little bit about our communities, at least as far as the representatives that are attending today. You guys are getting pretty quick at this, so I think I'm going to cut it off at about 5, 4, 3, 2, and 1. Okay. So we've got 6 said website only, 4 the email only, and 18 do a combination. For any of those of you who answered one or more of the above, how many of you are using, like, what's the primary thing? Are you using the website, the Facebook? Which is more predominant? Anybody? Website. Okay. And who uses Twitter out there in an association context? Is anybody? No? Okay. All right. Just curious. I have a Twitter. I've used it once to set it up, but and that's nothing wrong with Twitter. I just not sure. I just had to ask the question there. Okay, so a lot of us are using the website and the email and the Facebook. Right? Just a show of hands, how many have the Facebook? Okay, all right, cool. Well, let's talk about that a bit. If you're using any of these things, the thing that you may not have been aware of until pretty recently, because there's been a lot of discussion about this issue, is copyright law. Frankly, as community association lawyers, it's not something that we spent a lot of time thinking about until our clients over the last year or so started getting pinched. We have clients who have included snippets of magazine and articles in their newsletter articles and the emails that they send out. They've done the same thing with photos or posted videos to their websites that they didn't own the license rights to. Other communities have gotten threatening letters from one of those music industry corporations that I see some smiles. You know the letters I'm talking about, because there have been communities that have hosted movie nights or they stream music into the rec center, that sort of thing. That happened to anybody? You don't have to raise your hand. We'll have a question about it in a second, but that's what's going on out there. So these are just kind of common traps. So what you need to know about is, well, what is copyright, when does it apply, and why should you care? Well, in its most basis form, a fixed work of art, an original work of art, is going to either have a copyright protection or it's not. If it doesn't, it falls into what's called the public domain. A reproduction of a 16th century William Shakespeare, I hope I have my centuries right, at this point, is in the public domain. So you can copy that to your heart's content. You're not going to be sued. But what about if I've taken a prize-winning photo and you post that to your website or to your Facebook account? And if you're an association, well, there could be some liability associated with that, couldn't there? Copyright protection arises once the work is created. A common misconception amongst a lot of people, such as myself until I started doing the research, was that you had to do something special. Well, you really don't. Basically, if Kelly has the next great American novel in her head, the moment she puts that novel together in a word processor, boom, it's in a fixed form of art, it's an original work of art, and she owns the copyright to that. Now, you can do things. You can take steps to register your copyright to let the world know, hey, I've put some time and energy into this. Has some legal and practical advantages. Giving other claim holders notice that this is something that I've put together and I have a stake in, well, that can help you if you need to pursue some legal remedies. And in its most simplest form, if you don't register your copyrighted document with the Library of Congress, you can just do one of those. Have a copyright symbol, the author's name, and the year of publication. Okay? Questions about that? All right. There's a question? No. Oh, we're just stretching. Okay. Can you say that again? Yes. That when it comes to copyright protection, the law says that you don't have to do anything special to establish that you have copyright, that it happens automatically once the work is created. But the law also says that if you are sophisticated about it, a sophisticated copyright user, it is probably to your legal advantage and has some practical advantages to actually going through the steps to register your document with the Library of Congress and to also take additional steps in the event of a dispute. Okay? Question? Yes? Question is, how would you determine if something has fallen into the public domain? You'd have to do the research. There is the, yeah, it's, well, you know, a lot of that stuff is highly regulated now, and I believe you would just contact the proper, federal authorities. As a practical matter, I believe that a lot of those companies have really sophisticated search systems. It's kind of like, going to title, I would imagine, Okay. In terms of the follow-up, I think, to that is, well, how long does copyright attach? If I'm at home and I've just taken a photo or written a novel, it's just myself, I'm not intending it to have any commercial value, well, the basic bottom line threshold is my life plus 70 years. But the law has different spans. If the object is intended as a commercial product, it's a bit longer, 95 years from the date of creation. I guess depending how old the author is. I hope I'll be around. You never know. And if it's created by a corporation, it can be 120 years from the date that it's created. Question? Yes?
I have a question. I write poetry, and I've been published in 13 poetry anthologies.
Well, would you care to share any today?
And they're in the Library of Congress.
We have a poet among us, folks.
And I also design and make jewelry, Swarovski crystals, all that stuff. Now, whenever I design something or write a poem, I always date it. I'll take a picture of the jewelry, and it's date stamped. And with the poetry, I always sign and write the date on it. So does that help with the copyright?
I think it would. I think the fact that you've registered your poems with the Library of Congress is, a great step. It's one of the things we referenced. We have someone in the audience who has a passion for the poetry and also for the creative arts, the jewelry. I'm not really sure how it works with the jewelry because what you can't do is copyright certain types of things like a process. I guess you could have a patent, but there have to be some factors that would go into it. So yes, registering is definitely helpful. Other questions about that? Okay. So, what happens if you use someone's document or item to which copyright protection applies without permission? Well, it's called infringement. That's a bad thing. That's how you get into trouble. There's criminal liability associated with that, and also civil liability. They can be pretty steep. Someone can seek an injunction against you. So, if the association has a website out there that has copywritten material such as photos or videos, or articles, in theory, someone could go through the time and trouble of getting a court order to shut down the association's, website. That's an option. If it's something to which actual damages could be demonstrated, let's say that the poems that we've talked about are highly valued from their commercial standpoint, and now everybody is able to access them. Well, our author here could sue the association for the loss of revenue because now her poems are out there. and she can't control how they're distributed. Also, statutory damages can come into play, anywhere from, I believe, $750 to up to $30,000. And there's also a provision for willful or malicious. So you'd have to prove a high level of bad conduct, and I think this probably comes into play for those websites in which they're doing like file sharing of music, that sort of thing. Question?
So, as an example of using something on your website, if you were to go search for clip art on the internet and there's not a C or a TM or something like that, does that mean that it's not copyrighted?
The question is, okay, Javier, I hear what you're saying. I need to put a newsletter together. There's no copyright symbol with the copyright with the clip art that I'm looking at. Does that make it okay to use? And the answer is not necessarily, because it's not required. And so what I would do is I would recommend that you contact a well-established clip art house or library where you're getting a clean license, and you know that short of someone else being able to demonstrate, hey, the anthology or collection of clip art you've been given and have a license for, well, I never gave them the license for it, you should be okay. So that'd be the safest thing to do. Don't assume just because it lacks a symbol that it's okay to use. Kelly, you had a comment?
I'll just say it really quick. I've had a couple associations that have used something as simple as like a little picture of a shovel on their gardening page, and Getty Images has actually written them cease and desist letters. So it could be the smallest little piece of clip art that you'd think who would care, but if Getty is out there combing pages and finds it, you'll get a cease and desist letter still.
Kelly, how much are they asking for nowadays?
It was a while back. I don't remember. 5,000 is stuck in my head for some reason.
I take some pretty darn good
shovel.
photos. If you need a picture of a shovel, I'll get you one. Okay, defenses. I didn't know. Is that going to work, Kelly?
Probably not.
Probably not, that's right. But what about fair use? There is a defense under the law that if you're doing some reporting, like you're a newscaster, you're a reviewer for the paper, maybe you're a college or high school teacher, you're doing some researching, it's okay to use stuff to a certain extent. I don't think that's going to really apply in the community association context very much, short of some type of specific training. So there's a factor test that goes into play. What I want you to know is simply acknowledging that something belongs to someone else. This video was produced by Kelly Callahan, and I don't intend to, abridge her copyright or interfere with it. You see that a lot on like YouTube videos, that sort of thing. It's not going to keep you out of trouble. You're just admitting guilt. So don't do that. What do you want to do? Get some permission. It's called a license. Get a license. The licensing issue is rather interesting because even corporations from time to time get snookered. There was an article in the Wall Street Journal about 3 weeks ago where they paid a lot of money to some guy in China representing that he held the patents and the copyrights for some technology. And it turns out that the guy really didn't. So Apple had to go back and pay a lot more money to the real holder of that. So it happens to everybody. But all you can do is really try to protect yourself. Another thing that comes up is, hold on, we're jumping ahead here. I know, I'll tell you about that. Make sure you have the right kind of license. We have, in addition to people getting pinched for pictures of shovels, in the non-online context, we've had quite a few associations who do movie nights or who stream TV into the rec centers or play music throughout the community, like in the workout, fitness center, or they allow commercial use of their clubhouse. They have DJs who come in for weddings, bands, and that sort of thing. And what happens inevitably? There's that one guy or gal out there, they call in, they complain, they say there's too much noise, Mr. Police Officer, can you go out and talk to them? And in some of those cases, the police have said, hey, we're getting noise complaints. I noticed that you have a band here, sounds like they're playing some music. Can I see a copy of the license that you have to allow the music to be played? Well, guess what? If the DJ or the band doesn't have that, who's going to be on the hook, possibly? Well, the association. So kind of a side note or sidebar to what we're talking about today, but it is happening more often than you'd think. And in fact, I was at a luncheon the other day where they were talking about this very issue. A gentleman was sitting next to me, kind of gave me, the speaker, a funny look when they were talking about this situation. And I said, "Sir, this really does happen. You shouldn't take this lightly." He goes, "I know, Javier, it happened to me. That's why I'm laughing." So, okay. Well, what's this? This is a picture of, this is actually Stella in New Orleans. It's a restaurant that I went to. And this is the dessert tasting menu. You really can't see it too well, but it's got like 4 or 5 different creations. They're actually quite good. Highly recommend it. But let's say I am a budding professional photographer, an aspiring photographer. My life's dream is to put together you can have your cake and eat it too, kind of a coffee table photo montage album, and that's how I'm going to retire. And let's just suppose that Arizona HOA has a Facebook page. The administrator likes my photo, sees it somewhere. They copy it. They put my picture of dessert onto their Facebook page without my permission. And at this point, of course, I'm incensed because they're messing with my retirement and my copyright. And I then allege that the association is liable for copyright infringement. Would you say the association is liable based on what you've heard so far? Yes? No. It depends. I'm going to open the polling. And we'll give it another 5 seconds. 5, 4, 3, 2, and 1. Okay. 22 say yes, 2 say no, and 5 say it depends. Well, without further information, I would say the yeses have it. It's arguable that the administrator of the Facebook page could have some fair use, type of defense to the use of the photo without permission, but based on the limited facts available to you, it's kind of hard to see that. It would be pure speculation. So the association is going to probably be liable to me here.
Where did they get your photo?
People just follow me. No, I'm just kidding. I have no idea. No
Did you
idea.
post it to your Facebook page? Is it once you put it on Facebook, now it's everybody's?
True. Let's say I put it to my personal website.
Oh, well, that's different than
Okay.
your Facebook page.
That's true. True. Okay. So same scenario. I've put the photo. Let's clarify that because that's the point was, hey, what if you put it to your Facebook page? Do you still have own the copyright protections? Probably not under their terms of use. So let's say whoever snags my photo snags it from my personal website. Is that fair? Okay. So this time it ends up on the association's Facebook page without my permission again, but it wasn't the HOA's Facebook administrator that did it. It was a owner, okay? So that's what happens. I still say the association's liable. Yes, no, it depends. Let's see what you, as the audience, think about this. 5, 4, 3, 2, and 1. Okay, so the most common answer is B, no, 14, and then we kind of have a split between yes and it depends. Well, I'll tell you what, the association in this case is probably not liable. The reason being federal law, and this is some great news, I don't want to be a complete downer today. Here's what the law says. If you are running a website where you allow other people to upload documents, comments, statements, videos, anything like that, could be like a Facebook page, okay? Same type of thing. If someone else other than yourself posts copyright material that they lack the license rights to, so this is unlawful material, it's infringing material, if you, the administrator of the website, Facebook page, whatever, had no connection with this, basically, you're not liable. As long as you cooperate with that copyright holder's request to get rid of that material, you're going to pretty much be okay. That's good news. So from time to time, and I'll suspect you'll see this more and more in the future, you're going to get what's called a takedown letter. And it's going to come from the copyright holder's lawyer. It's going to say, we noticed on such and such date that such and such materials were posted to your thing, and we are requesting that you remove them. Our advice, follow the request. Because if it's not your material, who cares? So do that. You can get in trouble, though, if you are engaging in a such pervasive pattern. Like you have a website whose sole purpose is to trade like Justin Bieber songs, okay? And if you're letting people post those songs and everybody's trading them, that's not going to help you. You're going to get into different type of trouble. But the good news is, if association owners, disgruntled owners, board members, whomever, they put material up that they don't have the rights to, you're pretty much going to be okay. Questions about that? Yes? That's very clever question. The question is, should I have gotten permission to take the photo of the dessert? I don't. Of a person?
No, it could have been.
Oh, could have been.
Person.
Okay,
But
gotcha.
In your particular case, it was
Yeah.
the work of art of South Pastry Chef.
Yeah, I don't know that the.
Does that affect?
It can affect things, yeah. If we're taking photos of people that are in the public domain, meaning outside their house, then the answer is no. I mean, you don't have to get someone's permission to take their photo. And this question came up earlier this morning. The question was, well, is it okay to post photos of children? Legally, there's nothing wrong with it. Politically, that's an answer that you and your boards need to come to a consensus on. There's real policy concerns about posting pictures of minors on the internet. Lots of parents get upset about that. If you're having some type of outing and you're going, hey, this is the community's trip to the museum or trip to the zoo, you have something like that, you want to make sure you do what? You get a permission slip. It's okay to do this. Some boards have simply said, we're not going to post anything regarding children. Regarding works of art, that does get a little tricky. I think in my case, I'm probably okay because it's a dessert. But if I was, but now you're actually making me a little nervous. To be honest with you, I try to be really careful. So I hope the internet doesn't work well in New Orleans. That it can depend. There are certain places where the license that you're there, like at a ball game, for instance. You may have the right to take some limited photos at like a Major League Baseball game or spring training. Maybe you can even post it to your Facebook, but you couldn't, stream that a video that you had, online of the whole entire game. That would be a violation. So you're going to have to look at the context.
They post those to YouTube.
Yeah, but if you're posting like the entire game, like an entire spring training game from your iPhone, I think that would be a problem. Yeah, that would definitely be a problem. Okay. Safe harbor. Well, what's this safe harbor? We know that as board members and as community managers and community association lawyers, we kind of instill in every board member what? Follow the advice of experts. When you follow the advice of experts and you make decisions that are reasonable to a third person, that you're going to stay in the safe harbor and stay out of trouble, right? Okay. A similar thing here. Like I said before, if you cooperate with a request from a copyright holder to take offending material down, you're going to be okay, unless what? Well, unless you're running a scheme or you're trying to gain some type of financial benefit. Okay, let's talk about official and unofficial Facebook pages. Does anybody, out of curiosity, have any unofficial Facebook pages in their community? No? Okay. All right, well, here's an example of an official Facebook page. This happens to be of Anthem Community Council, one of our clients. On the next page, as you can see, it tells you who's running the Facebook page. This is the official Facebook page of Anthem Community Council. This is how you get in touch with them. Here's an unofficial Facebook page, White Tank Foothills Pulte. It's another community we work with. What's interesting about this is they set the Facebook page up as WTF Pulte. Now, WTF can stand for a lot of things. Most of them are very nice. In this particular example, although it's you can get a chuckle out of it, they're not really saying anything bad about the association. But it doesn't mean that the next disgruntled, and I'm not saying these are disgruntled owners by any means. But imagine if you had a contentious issue in your community, like removal of trees. I mean, that gets people riled up, right? Parking, trees, pick your poison. If a group of owners banded together and started up an unofficial Facebook page, because it's pretty simple to do, and now, everybody's out there looking for information. Maybe you don't have a Facebook page or website up. Now they're getting information from this unofficial site. That has the possibility to create a lot of confusion. I've done, and I know James has over the years, meetings where we've had these dissident groups of owners come together and say, well, we're the real board. They're not, really elected. And, I've actually had to go to 2 different board meetings on the same evening, one with an official elected group of people and with another one with, these dissident group of people. It gets very, very confusing, time-consuming, and expensive. So my point is, every now and then it wouldn't be a bad idea to just go out there, kind of Google your community, and just see what comes up. If something comes up that you believe is too similar to your association, and if you believe that it is the ability to confuse owners or potential buyers, it may be something you need to address. It's possible your community may hold some type of trademarks to the names of the association. Something you have to find out, of course, is, well, who owns the rights? Sometimes it's still the developer. In the case of Anthem, for instance, I believe that the developer, still retains a lot of those rights. But it doesn't mean that the board wouldn't have options. Another thing that can happen is cyber squatting. In that case, what you'd want to do is really establish not only who has the rights, but what's your best option. If someone has set up something that they don't have the rights to, like, they set up an Anthem webpage, they have nothing to do with Anthem, and they're just trying to make money off the Anthem name, it's possible that the holder of those copyright rights could go to one of those internet domain providers, I think they're called ICANN. You file an administrative complaint, it takes about 20 days. The cost is anywhere from $1,500 to $4,000, but you can get a response in about 20 days. That's not such a bad thing. You won't get any attorney's fees, you won't get any damages, but at least it's a way of quickly shutting down a possibly offending product or website or Facebook page. You could also, of course, file an injunctive lawsuit, just as you could with many other things. Okay, questions about that? All right, let's go on to our next example. We're going to move into defamation now. The association's administrator posts a comment to the association's Facebook page. Arizona dreamy landscapes stink. Their work gives the board nightmares. The landscaper, in fact, does a pretty good job, and most reasonable people would believe that, agree with that statement. Is the association liable here for defamation? Yes? No? It depends. Didn't realize I had a third answer in there. You can change your answers, folks. It only log your last one. Okay. Let's see. Survey says 19 say yes, 6 say no, and 4 people went with it depends. On this one, given the limited information that the administrator posted the comment, the person in charge, the official person in charge of the Facebook page, made a defamatory comment. It's something that paints somebody in a negative light. So it's not a very nice thing. And as they always say, truth is a defense, but in this case, most people from the information in the question would believe that Arizona Dreamy Landscapes does a pretty good job. It's probably a defamatory statement, and therefore the association probably is liable. And that could get pretty sticky. I mean, think about how many times people talk about vendors, even attorneys, community managers at the board level. We felt pretty free as a group to just kind of say this or that and exchange our feelings. Well, you want to be really careful about what you're saying when that statement can go out to other people. It's a way of definitely getting yourself into some hot water. So the advice here is be careful about what you say. What about the same scenario, except this time, instead of the administrator making the comment, A disgruntled owner did. They said, I hate our association's landscaper. I think they do a horrible job. Is the association, you think, liable? Yes, no, it depends. That's some quick voting, folks. There's some highly determined people either to get this question right or to get through this presentation. I'm not sure which one. Okay. And 3, 2, and 1. Okay, survey says, wow, it's unanimous. No. Okay, you have been listening. All right, I feel like we're making a lot of progress here, although I feel like you're teaching me. No. The point is this. The law says, again, you're not responsible for someone else's defamatory statements. The greatest analogy, greatest way of understanding this concept that I ever have had is thinking about, remember when there used to be bookstores all the time, like Borders, and there's still Barnes & Nobles, I think. I know, it seems weird. Let's say someone wrote Kelly is an author, and she's written a review of Community Association lawyers, and she goes, that Javier Delgado in Tempe, Arizona is the pits. He doesn't know anything. Horrible attorney. Don't hire him. Well, if that book is being carried by Barnes & Nobles, could you sue Barnes & Nobles for defamation just because they're carrying the book? No. They didn't author the comment. What are they doing? They're just publishing it. It's being carried. Same concept applies here. Now, here's where you get yourself into trouble, though. You want to make sure that you're acting like a publisher. And because being a publisher is good, authoring statements is bad. What am I talking about? Well, you can screen content, you can correct, edit, or remove content. You can be selective about what you're using. Solicit lawful content. You can't say, I'd like some MP3s that you don't have the rights to. You could pay someone to create content. All of that stuff's okay. All of that stuff is being a publisher. Where you get into trouble, though, is when you do this. You materially alter a content's meaning. Take the statement, Javier is not a murderer. He is not. I swear. If you change it to Javier is a murderer, you've materially altered that statement. Now you're on the hook for defamation, okay? So when people post comments to the website, maybe you didn't like the way that you phrased something, it's okay to kind of tweak it a little bit, but what you can't do is tweak the basic meaning. Because if you do that, and that results in someone alleging defamatory negligence, liability, you could be on the hook. If you decline to comply with a promise to remove material, that's going to get you into trouble as well. So let's turn now. Any questions about defamation online? Yes?
What about Angie's List?
Angies List, yeah. Good question, good question. When there have actually been a couple, Angies List, for those of you who don't know, I actually haven't used it myself, but my understanding is that it's like a review-based website or product where people can kind of post reviews. Is that your understanding? Okay, all right. It's as simple as this. If you give someone a negative review, well, guess what? That's your statement. And if the person decides to pursue you, they can go ahead and do so. If they can prove that your comment was not entirely accurate, then you've got some liability. So the other thing is be careful about what you're posting reviews to. That can get you into trouble as well. Didn't think about that, did you? Yeah. Okay. Well, let's move on to some final concerns. One of the things that we talk about in the office is enforcement and dealing with owners, dealing with disgruntled owners, because those are the ones that come to our attention. And what do you do with an owner when they say, you know what, the only reason that you declined to approve my shed was because I am Hispanic, or I am handicapped, or I am Vietnamese. In the past, management, what have you been able to say? Hey, we have no idea who you are. We're just, going around doing our job. You're nothing but a name and number on a property list. And I know it's more than that, but when we're doing inspections, let's at least agree that that's the starting point for inspections. We're just checking properties. We're not focusing on a particular ethnicity's properties. And we've been able to say that with a straight face. We have no idea who these people are. I mean, you don't, I have a very good friend of mine. He's a very prominent Phoenix attorney. He has an Asian-sounding last name. But you know what? He doesn't look Asian at all. So that's, we all have examples like this. But what if someone was such a frequent contributor to the social media website, to the Facebook page, and at this point, the board knows who this person is. They can see from the profile pic what race or ethnicity they are. The person, likes to tell you a lot of information about themselves. They might tell you that they are, lesbian or homosexual, that they're a veteran, all sorts of stuff. Well, the more information you know about someone, that can become problematic because once that bell's been rung, it's very difficult to be unrung. And be aware of this. The Arizona Attorney General is at this very moment kind of looking at this thing from the context of, hey, when people have social media policies out there, what policies are too restrictive? And even if you say that you're not looking at someone's profile, do you have any proof about that? Because if they can show that you have been doing that, well, you might have to do some explaining. So my advice would be to just be aware of it. It's kind of hard to regulate it, but address it in your policy. We'll talk about that. All right, so in closing, how do you keep yourself out of trouble? Well, you're going to want a social media policy. It really should have a stated purpose. The purpose is to distribute information to our membership, to focus on community association issues. You want to list disclaimers such as we're not responsible for user-generated content. You want to define prohibited content, specifically discourage people from making negative comments about their neighbors or vendors, warning them that if they make these types of comments, that it's going to be their problem to deal with. Address profile viewing, the thing we talked about a minute ago. Be very clear about how the administrator is going to be using that information. And finally, you define content that is subject to pre-approval and who's going to be in charge of it. Okay, so that concludes today's seminar. We have 2 upcoming seminars. I hope you'll join us, and we'll open it to some questions.
I have a question about hyperlinks.
Excuse me, I'm going to grab some water.
And you don't want to update the information all the time, so you just hyperlink to the city of Chandler on your association.
That should be fine. Yeah, there's been a case law, and also the law addresses that linking is fine. Yes, the question is it okay to list links like to the city of Chandler's office? And the answer is yes, that's fine. Question in the front.
Question about document retention. It said meeting minutes is included in the data retention for indefinitely. Really? Really? Meeting minutes, 30 years old, you gotta keep them?
Kelly, would you like to address that? The question is that meeting minutes need to be maintained by the association indefinitely.
It doesn't really contemplate, that requirement is found in the Nonprofit Corporation Act. So what you can kind of envision is a corporate body that probably doesn't meet all that often, keeping its minutes indefinitely as permanent records. It becomes cumbersome when you're an association that meets every month, I understand. The best policy is to comply with the statute and keep the minutes that you have indefinitely, but to the extent it's just a complete burden, then I suppose the best thing to do is to adopt a policy that says how long you do intend to keep them for and when you will destroy them after a certain age. But like I said, the Nonprofit Corporation Act lists it as an indefinite record. So your best bet, even though it's a pain in the neck, is to come up with a way to perhaps synthesize the data into a smaller storage means, whether it's maybe a zip drive or an off-site location is probably the best option.
Other questions? In the back.
You've been speaking to Facebook and websites. Does all this apply to blogs as well?
The question is the advice that we've given today and the analysis that we provided specifically referenced examples using Facebook, social media, and websites. Does it also apply to blogs? The answer is yes. The analysis would be the same. Okay. Well, Kelly and myself will hang around for a few minutes. If you haven't had a chance, please go ahead and be sure to fill out the feedback form. and we hope you'll join us in the future. Thanks.